Hello, everybody, and welcome to today's panel, Confronting the War on Immigrants, Citizenship, Detention, and Deportation. I am Tonga Leslie, Director of Policy and Program for Racial Justice at ACS, and your host for today's event. Now, as I'm sure all of our audience know, if you're following the news, the current president, Donald Trump, has made attacks on immigrants a cornerstone of his political identity. And now that he's returned to office, there has been a lot of executive action on immigration. We've seen executive orders attempting to remove birthright citizenship. We've seen expansion of expedited removal. We have seen the authorization of ICE to now enter previously safe spaces like churches, schools, and hospitals. And we've also seen the beginning of efforts to build unprecedented detention centers in Guantanamo. So it's a lot to take in, and it can also be difficult to feel like we're constantly chasing the headlines and reacting. That's why we're really grateful for today's experts for making more of a space for us to zoom out. We'll, of course, look at some of our current developments, but we also want to just be thoughtful about the larger context we're in, and most importantly, for all of you in the audience, think about ways that we as progressive lawyers can try to fight back and hold the line. So we're going to start off with some presentations and Q&A from our panelists, and then at the end, we'll have some opportunities for Q&A from the audience as well. I'm very thrilled to host our two guests today. We have first Anna Raquel Minian. She is an associate professor in the Department of History at Stanford, where she specializes in Latinx history, immigration, histories of incarceration and detention, and modern Mexican history. Her book, In the Shadow of Liberty, The Invisible History of Immigrant Detention in the United States, came out last year, and she's the recipient of Andrew Carnegie Fellowship, among many other awards. So we always have abbreviated bios here, but we're very pleased to have you with us, Professor Minion. And I'll start with you before getting to our second guest because I've got your book here, wonderful read that we forgot that you can't do virtual backgrounds on these. Well, In the Shadow of Liberty is a fantastic read. Um, and would really love to know if, just as a starter, what inspired you to take on the work, and what did you learn in your studies of the large system of detention that undocumented immigrants face?
I I'm a professor of questions of immigration, and as I was reading the literature, I had just finished my first book in 2018, and it was on issues of immigration. I thought I was an expert on the issue, but I knew very little about detention. And then in 2018, President Trump began to separate children from their parents whilst in detention. And I didn't understand how that was possible, how it was imaginable even. So I decided to explore this history and to come to understand the long history of detention, which truly begins from the federal government in 1891 to the present. And I discovered, as I will talk about today, the many similarities between the past and the present, and what the past tells us about current policies and how we can understand current policies. Should I go on, or are you going to?
Yes. So of course I think that was a moment where a lot of folks started to pay attention to the conditions that folks face. I'm curious, sort of leading that larger context, because it seems like it's not just something that started this term or even the past, 4 years with his first term. So can you explain to me a little bit the history of that?
Yes. So up until 1891, the government didn't really allow for immigrants to be detained within the national territory. Instead, when immigrants arrived on vessels, the government would hold them there while adjudicating their cases. This, of course, created massive problems for the vessel companies that needed to depart. They couldn't just stay in the ports while the government often took months to adjudicate their cases. So in 1891, Congress passes a law that allows immigrant detainees to be held in the interior of the country. But part of that law says that while immigrants can be detained in the United States on the US map, they are to be considered, imagined as if they're not here. That means that because they're quote unquote not here, they can be held in Chicago, let's say, but imagined to be elsewhere, and as a result, have no rights. They can be held without trial, incarcerated without trial, face all sorts of abuses, detained indefinitely. And this, which we call the entry fiction, continues to this day. The history of immigrant detention continues until, and there's a big change in what happens in 1954. Up until 1954, the government continued to expand government detention sites because it claimed that it needed to stop immigrants and decide whether they had the right to enter or not. Since the Chinese Exclusion Act, the government had increased the number of people and the number of categories of people that it was barring from entering. In 1954, the Attorney General decides that this is no longer a sound policy and that most immigrants who arrive can be let out on parole while their cases are being adjudicated. And we see a sharp decline in the levels of detention. And not only that, but we see that the government logic changes. Now the government decides, actually, we don't need detention centers. We can just let people out. That again changes in 1980. I'm giving you the broad strokes here. In 1980, there's two things that happen. One is, and the major one is Fidel Castro announces that anyone who wants to leave Cuba can do so through the port of Mariel. Before that point, Castro, for the most part, prevented Cubans from leaving the country. So many people, many Cubans who wanted to depart, to come to the United States, left from the port of Mariel to the United States that year. Now, of course, this caused a propaganda problem for Castro because so many people wanted to leave to the United States that as these boats were sailing here, Castro announced those people are criminals. Of course, this created massive commotion among Americans. President Carter, who had previously said that he would receive these Cubans, known as Marielitos, with open arms, suddenly began to hold and to incarcerate them. And because of the entry fiction, even though most were paroled afterwards, they held no rights. The entry fiction followed them. So no matter how small a misdemeanor they committed, for example, if they couldn't pay their hospital bills, they could be detained indefinitely in US jails and prisons. And this is what happened. The
I want to
expansion.
pause you. I want to pause you there because I think there's already a few a few really interesting nuggets, and I know you're going to bring us to the present, but one thing that's fascinating is the entry fiction creating these constitution-free zones, essentially, or very light constitutional protection zones. Um, and sort of how scary that concept is of people being held indefinitely from something that is just factually not true. They are on U.S. soil, and the 14th Amendment is supposed to protect everyone on the soil. But I also am hearing here this fascinating texture of all the different ways that we've dealt with undocumented folks who are awaiting their status. And it's just very refreshing to know, oh, this is actually not the only option. It's possible to have people who are not being held, and that has been considered viable previously, and how much the idea of criminality is even something that is up for grabs and can change from moment to moment. So I will come back to you on the present because I know we've only gotten to the 80s, but I want to use this chance to bring in Professor Frost, because she's also writing from another end of the spectrum. So we're joined by Professor Amanda Frost. She is a professor of law at the University of Virginia School of Law, where she writes and teaches on immigration, citizenship, and federal courts. And she also runs a fabulous immigration clinic. And her her book, You Are Not American, covers jurisdiction stripping from Dred Scott to the Dreamers, came out in 2022, was also shortlisted for the Mark Lighton History Prize. So I think it's very interesting. We're working from opposite ends. We all have clearly the folks who are undocumented living with very few rights. But I think often we think of citizenship as like this safe harbor. Like you'll get there, and once you've gotten to the other side, then you're good, you're safe, you've become a citizenship, and that's a stable status that can't be taken away. And I'm curious about if you can talk to us a little bit about your book and what you discovered about how that's been less than stable and who it's been less than stable for.
Yes, I mean, I think that's the question that really motivated my interest in writing that book. And I should say, in addition to the book I published on the history of citizenship stripping in the United States, I am currently work on a book on the history and the legal and socio-legal value of birthright citizenship, which obviously is now in the crosshairs. So those questions really interested me. The title of this webinar today is Confronting the War on Immigrants. And I think it raises the question, well, who is an immigrant? Who is in the crosshairs? And who is a citizen and is, safe, right? So I'm going to just quickly run through a couple of points that I think come up through these executive orders and the debate we're having today. And I think there's a conversation that's been missing by immigration advocates over the last decade, because the focus has so often been on the humanitarian reasons to accept immigrants into the United States. Of course, we think of the Statue of Liberty, the famous quotation of "We think the tired, the poor, the huddled masses." It certainly, providing a safe asylum is certainly something that the United States is rightly proud of in its history and as part of our, the history Anna tells, was a history initially of a country that did think of itself as having limits on migrants. But the points I want to make today are not going to be focused on that. They're going to be focused on the fact that in a world in which we are now targeting immigrants, the question is, well, who's being targeted? And I think there's an assumption by a lot of people that, well, that's other people, maybe people even that I sympathize with and want to help, but it doesn't affect me. So I just want to quickly run through a couple of points to be made about this, because they're part of what interests me about this area of law and also what concerns me. One is, well, who's an undocumented immigrant? You might say that's the first person we could target, right? Like whatever happens, the undocumented immigrants, certainly the mainstream American might think, well, not a problem, right? They're here without permission. But if you dig in a little bit, we see that the administration has referred to undocumented immigrants as, or call them illegal aliens, people who are legal. So the Haitians in Springfield, Ohio, are here under the Immigration and Nationality Act, Section 244. They are not illegal. They have a legal right to be here. They're not undocumented. They have paperwork. Same is true for asylum seekers, who people also call undocumented immigrants, but they have a legal right to remain under Immigration and Nationality Act 208. So if we're a country of laws, at least a large group of people that are affected by these orders who are referred to as undocumented immigrants or illegal aliens are legally present. A second point to be made is that this attack on immigrants, including undocumented immigrants, seems to stop short of the US citizens who employ them. They're 8%. Undocumented immigrants make up 8% of the economy of workers in the Texas economy. Texas has not adopted E-Verify, which would be a mechanism for double checking to make sure that the people that are working for employers in Texas are in fact legal. Texas could do that. Other states have. Texas has it only in part. Other states have gone far further. And all this suggests to me that the war on immigrants is not really a war on undocumented immigrants or illegal aliens, or an effort to deport them or get rid of them, as so much as it is to create and instill fear and maybe to have a political rhetoric or talking point. Because if you did deport all of those people in Texas and all the people harvesting the crops, of course they would suffer, but I'm not even going to speak to that. The people that would suffer would be the people remaining in the United States of America, who needs them to harvest the crops, who needs them to do the construction work. So, the first point is, who's an immigrant? So it's not, the undocumented population. You might say, well, that would be a population we could target. But when you look at actually who those executive orders are aimed at, it goes beyond that group of people, for sure. And also, I wonder if they truly want to remove them. So that's one question. Moving on, of course, to people with green cards, right? You'd think the most stable source of immigration status you could have, a green card or lawful permanent resident status, means you get to remain in the United States indefinitely. You could naturalize from that status after you've been in the United States for 5 years. You might think those people are rock solid, right? And their status is safe. But if you look at the Immigration and Nationality Act, you see there's a number of provisions that allow for deporting or removing non-citizens. If you look at the executive orders issued by President Trump, you see on this first day in office, you see that it would allow for removal of people that appear to be a terrorist threat, and that's defined very broadly. We look back at Supreme Court history, which Anna knows well. You see that the Supreme Court has allowed removal of non-citizens for engaging in what sure looks like protected speech, even if they're green card holders. So again, that's a group of people that's far broader, right, than that I think most Americans think when they think, oh, we're targeting immigrants. They don't think, well, we're targeting green card holders. And then I'll move on just quickly to naturalized citizens, the subject, part of the topic of my last book project. Naturalized citizens have, you might think again, well, they're safe now, right? They're citizens. They've come as immigrants, they've qualified for citizenship, they're now citizens. Under the last Trump administration, there was an effort to target naturalized citizens. There was investigations opened up into 700,000 naturalized citizens. There was an office opened in Los Angeles, staffed with 30 plus people at a cost of tens of millions of dollars to investigate these people. And the Trump administration, in the executive order entitled Protecting the United States from Foreign Terrorists and Other National Security and Public Safety Threats, it included a line that said, we need to ensure adequate resources to identify and take appropriate action for offenses described in, and then it lists the denaturalization statute, section 451 of Title 8. So you're not safe if you're a naturalized citizen. All right, last category, birthright citizens. Those people can't be the kind of people being targeted as immigrants, right? But of course, I'm sure I'm not telling anyone anything they don't know when I mention there's an executive order that questions birthright citizenship. So those are the questions that interested me. And in part, it's because I think this conversation has so often focused on the desperate, the poor, the asylum seekers, for which I personally have great empathy. But I want to make the point, what this administration is doing and what it did last time around puts just about everyone at risk, especially now with the executive order on birthright citizenship.
Thank you. That is honestly quite chilling when you get to 700,000 folks who would think that they have legal status and the millions more that you've named. And, I think expanding that scope of who's affected by these systems is extremely important to prevent the divide and conquer. It actually makes me want to loop in Anna here because one thing that was very shocking to me from your work was your talk about how the growth of mass incarceration and mass detention have similar roots and sort of have cross-pollinated, which I was completely unaware of. Would you be willing to talk about that? And maybe that gets us into the 90s, into the present.
Of course, and yeah, it speaks a lot to how detention has also affected American citizens. I do want to add one point about American citizens and how they are affected with deportations, which is the communities of those who are affected. What are their rights to keep their family members to not be separated? And that is something that we see in detention as well. The history of detention and imprisonment have long been linked since the beginning of the of federal detention in the United States. There was no space at first, so people were put in U.S. jails. As detention centers started to be built, there was this rift between those people who wanted more prisons and those people who wanted more detention centers. But what came out of that, especially in the 1980s, was the idea of let's ask for money for Congress because we're incarcerating immigrant detainees. We're putting them in prisons. So alongside with the war on drugs, we can criminalize marital Cubans who we already assume are criminals. We can say, we're putting them in prisons. We need more money for prisons. we also need more money in the same logic for more detention centers because these spaces were overflowing. Now, as more detention centers and prisons were built, the result was not better conditions, was not less overcrowding. It was simply more people put in prisons, more congressional money being allocated to the growth of imprisonment and immigrant detention. The other strong link that we see is one of the main things that we think about that are a problem with the prison system, which is the creation of private prisons. In fact, the first private prison in the United States was an immigrant detention center, because prisons were so overcrowded and detention centers were so overcrowded. Private investors came to the Attorney General and said, we have a solution. Let's create a fully privatized prison where everything is run by private capital. And that was in 1983, this prison opened. It was the first time that there was a fully run private prison, and it was used to hold immigrant detainees. Since then, the expansion of private prisons has boomed, but it really started with the history of immigrant detainees. Now, of course, it's also used to imprison citizens.
So we've been talking sort of at the systemic level, right? These systems and these statistics. And yeah, one thing I found interesting is both of your books are really very deeply grounded in individual narratives. You both sort of name individual people and you kind of draw that out. And I was curious if you could speak to the reasoning behind that decision, and if there's any compelling narratives that came to you through doing this research that you think are worth sharing or lifting up.
Amanda, do you want to go first? Or...
Sure, I'll just mention sort of, my theme for today is to focus on the fact that the war on immigrants is very likely to affect many more people than I think the typical American would think, in part because of the very broad definition of who is an immigrant who could be targeted and the very precarious legal situation of even green card holders and even naturalized citizens in the United States. And I think Anna's historical work on this really shows that theme throughout US history, that what starts off as a small targeted, we don't want to let Chinese immigrants into the United States was the initial impetus, and then it expanded through a bureaucracy, through the use and need of paperwork and surveillance to affect all of us. And immigration, every single person has to prove that they're allowed back in the US. And obviously it's fairly easy for many of us with passports or birth certificates, but the government controls that. And that was the expansion of the immigration bureaucracy was definitely the result of an expansion of immigration surveillance and a targeting of various groups that expanded beyond the narrow initial focus. So this point of the book, in terms of, to answer your question about, why did I pick to write in this sort of narrative nonfiction style, and why did I focus on individuals? Each chapter of my book, You Are Not American, focuses on an individual story that then I use to sort of spin out and explain the phenomenon more broadly. It's partly because I think stories and narratives are what connect with people. It's also what most interested me. The people were also extraordinary in the ways in which they fought back, often successfully, to retain their citizenship. And the last point I'll make is one story in particular really resonated with people. I'm almost troubled by how much it resonated with people, and it resonated with me, and I'm troubled by the way it resonated with me. And it was the story of Ethel Mackenzie. And that's because she was a white woman living in San Francisco at the turn of the century who fought successfully for women's suffrage in California. But she married a non-citizen, a sort of colorful Scottish opera singer. And when she went to vote under a federal law in place at the time, from 1907 till about 1930, US citizen women who married non-citizens automatically lost their citizenship, whether they were birthright citizens or not. And so she brought a case to the Supreme Court, lost 9-0. Eventually the laws were changed. I tell that story in the book. But it really resonated with a lot of people because I think people thought, well, but she this wealthy white woman born in San Francisco, daughter of a vintner, socialite, surely she was safe. And I think that's my point. Like, the minute you start thinking, well, that's other people that are affected, I think you lose some of the rhetorical power. And I was trying to make people realize everyone could be affected by a redefinition of citizenship or belonging or immigrant.
I was also driven by similar reasoning while following individual people. Most of the news that we read, we see numbers, and I wanted to bring the humanity to capture the experiences of people who are held in immigrant detention, to show their flaws. And that they don't need to be perfect to not fall into this system where laws do not abide. So to show the long history of immigrant detention, I follow the laws, but I do follow them and the changes, but I follow them through the history of 4 people. The first one is Fu Hao, a Chinese immigrant who came. He had worked in, he had helped American missionaries in China who were being killed in the Boxer Rebellion of China. And he came legally because he was a student. And despite Chinese exclusion, the Chinese Exclusion Act had certain people could come in, and students were one of them. So Fu Hao had risked his life for Americans, had come to the United States legally, and then was detained. The entry fiction, where he had no rights, did not know when he was being released, did not know why he was being detained, affected him. After that, I follow the case of Ellen, who was a German Holocaust survivor. She was Jewish. She then married a GI, an American GI, came to the United States only to be incarcerated in Ellis Island. Of course, Ellis Island is considered the site of opportunity and the welcome of immigrants, but it was also used as a detention center. And later it was found that she was being detained for the silliest of reasons. Her husband's ex-girlfriend had accused her of being a spy because she was jealous. Following that, I tried to show how immigration detention waned from 1954 to 1980, and show the regrowth of immigrant detention through the story of Gerardo Mansur. He was he escaped from the Mariel boat lift, arrived in the United States, was originally detained, then built what was truly the American dream, made a lot of money, had a wife, had 2 American children, but the police came and found less than an ounce of marijuana in his house. And so, because he was a subject of the entry fiction, detained him indefinitely in a maximum security penitentiary. Like Fu Hao, like Ellen, he had no idea why he was being held, if he was going to be released. He had no access to a hearing. And after that, I show the growth of immigrant detention and the abuses that can happen through the story of Fernando, who experienced family separation under Trump.
Very, very powerful stories. And it seems like, one of those themes is this sense of security at any part of the spectrum that you're on can be pierced more easily than one might think, whether you're this, wealthy socialite who we'd never imagine, or even folks who have sort of checked all the boxes and think that they've arrived to the American dream. And it makes me think that this might be a good time to talk about courts and the role the courts have played in all this. But before I do, I want to give folks our first CLE word of the day. So our CLE word today will be harbor. That's the first one. And you can use the website where you registered for this event to find the certification and everything you need to report CLE to your jurisdiction. Okay, but back to courts, because we've got some questions in the chat. One of them is, were these constitution-free zones ever tested in the Supreme Court? So I'm curious from both of you, how have the courts, been on this and in serving as a check on abuses in the immigration space, on preserving due process? Where, if anything, have there been bright spots, and where are there, points of weakness?
Yeah, so the Supreme Court has ruled many a times around the question of the entry fiction and these, and like legal free zones. It did so earlier on when it was first implemented and decided that that the entry fiction could continue. And then this was further reinforced, and this is part of the reason I chose Allen's case, the woman who was a Jewish Holocaust survivor. She arrived in the United States in 1948 or 9, and her case ended up going to the Supreme Court. Now, I have to say, she was not fighting for the right to not be detained, like habeas corpus. She was simply fighting for the right to a hearing, not to the right to enter the United States, for the right to a hearing. The Supreme Court ruled in favor of the entry fiction. She did not have the right to a hearing. That was reinforced a few years later with a very similar case. And then in 1996, Congress passed another law that basically said, actually, the entry fiction doesn't just apply to people who are stopped at the border, but now it applies to all undocumented immigrants, including those, who can be apprehended in Chicago and Los Angeles. And yet, up until recently, that distinction hasn't really played out in the courts, and the entry fiction has continued to matter. One of the things that I want to emphasize with the issue of the entry fiction and these legal free zones is that they act very similar to legal black sites. In fact, the first time Guantanamo was used was not to hold terrorists or enemy combatants, as George W. Bush claimed, but it was used by his father, George H.W. Bush, to arrest Haitian refugees who were coming. And part of the reason that they were able and they defended their right to hold people without rights in Guantanamo, in part it was because it was not in the mainland, in part they said it was part of Cuba, even though it was not, they didn't really know, it was nowhere, but also they defended it through the entry fiction. Immigrants had not already landed in the United States, and so they deserved no rights, even though they were being held in a space controlled by the US military.
Yeah, and I'll just add that the Supreme Court jurisprudence tends to be very deferential to the government when it comes to immigration. There's a doctrine called the plenary power doctrine, established in these cases involving the period I was talking about, the Chinese exclusion era, in which the Supreme Court upheld both the right to exclude. It was at that point a Chinese immigrant trying to return to the United States who had all the paperwork he thought he needed. He'd been living in the United States. He left briefly to visit family. He tries to come back in the 1890s, and he's barred by the Chinese Exclusion Act and by a change in law that meant that his paperwork no longer was good. And he couldn't have known that before he left. He left with the right paperwork. And the court said that was fine. And then in a subsequent case, they allowed for the government to deport people, Chinese immigrants living in the United States. And those cases, Che Chan-ping and Fang Yue-ting, are the sort of backbone of what we call the plenary power doctrine, that the US government has not completely unfettered discretion, but enormous discretion and authority over immigrants, and the courts tend to be very deferential to zip forward in time. I mean, we saw the travel ban upheld by the Supreme Court in Trump versus Hawaii, and the court didn't completely abandon the field. I think that's important to say. It did say it would scrutinize an executive decision to ban certain people from certain countries, as was it facially legitimate and bona fide, but it was really not willing to give much close analysis to what was going on, and was going to defer to the executive, and it repeated that idea. The last point, because it's about the last book on denaturalization, the Congress and the president had been very aggressive about trying to denaturalize people with communist sympathies or affiliations in the 30s and then in the 50s again during the Cold War era. And the Supreme Court, in a 1967 case called Afrin versus Rusk, finally put an end to it. And it said, the people choose the government. The government can't choose the people. It could see suddenly that if you let the government have the power to control who is a citizen with all the rights of democratic participation and the right to remain, what a disaster that would be. So they put a stop to it, but they left in a footnote and this idea that, well, but if there was fraud in the naturalization process, that would be appropriate to denaturalize somebody. And by the way, I agree with that idea. But it left this enormous loophole through a very broadly worded statute that means the government can go after and investigate hundreds of thousands of people, potentially denaturalize them for very minor problems. And the courts don't really have much to say about it. They have to review these cases. It's up to them. But the law is so broadly written and without any statute of limitations that I think the law itself is a problem there. I'm not confident we'd get Congress to rewrite that today. But again, I'll just point out, it's not just, illegal aliens that are at risk. It's even people that are naturalized and think they have a secure footing in the United States who potentially could be subject to investigation, scrutiny, and removal.
So we are coming to the point where we have to talk a little bit about what's presently going on as well. And one that I want to throw back to you, Amanda, especially because there's so much inquiry in the chat about it, is Wong Kim Ark and this idea of birthright citizenship, that's been something that folks have thought, okay, well, that's settled precedent. And yet there are some conservative scholars who are trying to bring up, well, are there loopholes? What does it mean to be in the jurisdiction of the United States? And so, reading the tea leaves is often a fool's endeavor, but I'm curious your thoughts on how settled that is in this current court climate with the administration we have.
Well, I mean, first I'll say this is a topic dear to my heart since I'm writing a book on birthright citizenship. And I think, as I'm saying in the book, got some draft chapters, this idea of birthright citizenship is so essential to what it means to be an American. We are about location and not lineage. And that was a founding ideal that we've had. We didn't live up to it initially, of course, and Dred Scott, the infamous Dred Scott decision, really drove that home. But that was the goal of the Reconstruction Amendment, the 14th Amendment, the first sentence of which says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And the Reconstruction Congress, when they were debating this, they said, we need to put it in the Constitution because we know that in the future, new elections will result in new people taking this office and they might want to reverse birthright citizenship. And boy, were they right. We see it today. Although only an executive order. And that's another reason to think that maybe it won't prevail. So just a quick background on the Trump administration's arguments, and it's very few legal scholars that support this. There are a couple, but the Trump administration is clearly on board with the idea that they say, that phrase, subject to the jurisdiction thereof. They say, well, that excludes, and then they list a bunch of groups it excludes. By the way, I'm not sure they'll stop even if they win where they've at the line they've drawn. They say the children of undocumented immigrants are not subject to the jurisdiction of the United States and therefore aren't birthright citizens, and the children of legal immigrants who are temporary, not green card holders. So students, temporary workers, people who are executives or who are here as part of religious affiliations, working for a church in the United States. All of those people, even if they're in the United States for years, even if they're in the process of getting a green card, their children are born under the Trump administration's executive order, would be born undocumented immigrants who could be deported the first minute of their lives. So it's extraordinarily broad. The rationale, I frankly, I've read all the briefs. I couldn't articulate it because I don't fully understand it. But I will say, for those who are curious, they might say, well, but why was there that initial, decision to put in the caveat or limitation that birthright citizenship only applied to those, quote, subject to the jurisdiction of the United States? What is that phrase doing? So that the legislative history here from 1866 is super clear. They wanted to create a carve-out or exception for the children of diplomats. I mean, that's always been an exception to a common law rule. You don't want the French ambassador to have a child while they're in the United States and that child to be an automatic citizen. The French ambassador doesn't want that. And it also accepted the children born within Native American tribes. And the debates and the argument made the point, these people are not fully subject to US jurisdiction. They're separate sovereigns with their own laws and courts, and they are not automatically included for those reasons. And I should just add one postscript, which is in 1924, Congress passed a law. So by statute, all children born within Native American tribes today are also birthright citizens, but it's by statute. And that's the work the subject to the jurisdiction thereof is doing. It is not meant, no one's ever interpreted it before, to mean that people who are here on a temporary basis, their children aren't citizens. That's brand new from the Trump administration.
Very, very helpful. You know, it brings to mind maybe this, we have all these attacks, and I think a lot of folks want to know, okay, so what can we do to actually resist if you aren't on board with the immigration system or the way things are going, how do normal people get involved? What's possible for them? Um, and very curious to you about, especially drawing on, history if you can, since you've looked at now hundreds of years of people sort of riding with the punches on this. What do you think people can do at this time?
I'm happy to jump in, but don't want to, Anna, if you have thoughts, I don't want to.
I do, but why don't you go first?
Okay, I'll just say what I've been saying to my students and to other members of my community who've asked the same question. First, there are so many opportunities to volunteer and assist, to work with lawyers, particularly if you're a law student, to do pro bono work on behalf of individuals and communities who have pathways to secure status or who are in need of maybe a new document, to renew their green card. It's something they have a legal right to do, or children who have a right under what's called special immigrant juvenile status to get status. So there's lots of work, especially for law students, anyone in the legal community, law firms, which do a lot of pro bono work and deserve credit for that. There's lots of ways to use those legal skills to assist people that are at this point in a really precarious situation. So that's one piece. Of course, the other piece, and this is something I really resonated to me as I wrote the book, where I focused on all these stories of citizenship stripping over US history. The fight is all around. You can't just stop with courts. You can't just stop with trying to convince members of Congress to support legislation. You have to be reaching out at every turn to everyone in your life to try to explain the significance and importance of this. And I was really struck by the fact that I've been reading articles about how Venezuelan Americans say they feel shocked and betrayed that President Trump ended TPS, temporary protected status, for Venezuelans. And they voted for him thinking he wouldn't do that. And I feel like that was a failure on the part of myself and people like me. How did we not get that group that message? Because it was clear to me he would end TPS for Venezuelans and everyone he could. So I think one of the goals is to get people more engaged, even at this dispiriting time, and to educate people. It's not just some undocumented immigrant who's a criminal that's going to be affected. It is people in your community. And if nothing else, your grocery prices are going to go up if Trump succeeds.
Yeah, I want to reinforce what Amanda was saying in terms of joining organizations. At the end of my book, In the Shadow of Liberty, I listed many organizations, many of them legal organizations that you can support, that you can join as legal scholars. I also want to add, and we see historical patterns, raising your voice, protest writing in newspapers, even though it seems it doesn't matter, it has mattered historically. So that's how Fujihao was let out. Ellen Snuff's case, even though she lost in the Supreme Court, as I said earlier, she was released into the country because newspapers wrote about her case time and time again, that the Attorney General was like, let's just let her out. We see the same with Mariel Cubans, and we even see that with the family separation policy that Trump implemented. Only a quarter of Americans ended up supporting family separation. It was his most unpopular policy. People in strongholds like Los Angeles, but also in places like Appalachia, came out to protest the zero tolerance policy, and Trump ended it. That did not mean that family separation ended, but zero tolerance policy did. And that's because people raised their voices. And so that's what I would encourage also people to do.
Yeah, and I would just add quickly that I think it's a mistake we've learned it from long ago, and we see it again, to always think, well, the courts and the law will be the answer here. I mean, the law is, and I think should be, very much interconnected with the political process, with public opinion. And that's where you need to be having your voice heard in every forum. But certainly the courts, but also in the halls of Congress, in your local paper, at your school board, with your family. You can't succeed if you simply seek to make your voice heard in court.
Very helpful. And I think big lessons that we've been learning as attorneys these past 2 years. I want to get a few pointed questions from the chat. One comment, how can you be not subject to this jurisdiction and yet you are being controlled by the US? That's great. I also see a couple of questions. I'll maybe bundle these. One couple of questions seem to be focused on, do the attacks on birthright citizens affect children who are born overseas to military parents? That seems to be a big one. And then there are also some questions about sanctuary cities and local resistance and whether that, whether that right still exists and how that's looking.
Yeah, well, and I love that comment because it is, what do you mean undocumented immigrants or the children of temporary lawful immigrants aren't subject to the jurisdiction? Are they allowed to break the law? Can they stay forever? Of course not. Like, that's, immigration laws apply to them. If they run a stop sign, they can be fined, they can be arrested. No one doubts that, least of all the Trump administration. And I've read all their briefs on this, and they do not, I frankly don't think it makes any sense to draw the lines they draw. And certainly the Reconstruction Congress nor the nation, when it ratified the 14th Amendment, thought it was drawing those lines or said anything about it. So the question about those born abroad, whether to military or otherwise, so the executive order doesn't target those groups of children born abroad to US citizens. Although I'll point out there's two ways to become a citizen. Well, three. One is naturalizing, if you're an immigrant, through the naturalization process, where you start off as a non-citizen and then go through the process to become a citizen. We see the Trump administration targeting naturalized citizens in the last administration and saying again, it's going to do it again in its executive order this time. Then we see another way to become a citizen is to be born in the United States. And we see a targeting of that, obviously, in the executive order. And a third way to get citizenship is through descent. So someone who's born abroad to US citizen parents, if the parents have lived sufficient time in the United States before that child is born, that child's born an automatic citizen. That's by statute, not by constitutional right. I have not seen anything in the Trump administration seeking to target and prevent people from getting citizenship who are born abroad based on citizenship by descent through inheriting it from their parents. But frankly, I mean, we're in a situation in which the Trump administration's targeted lots of groups it never has before. So I wouldn't put it past them.
And just like with the jurisdiction question, you pointed out how absurd it is in some ways. The entry fiction, where people can be detained here but be considered not to be here, is equally illogical, and yet it is part of this law from 1891 that continues to be implemented today. If you're stopped at the border, no matter what the definition of the border is, it could be 100 miles into US territory, you're stopped in the border, you ask for asylum, let's say, when you're arriving, entry fiction applies to you. And yeah, detention centers now are very far from the border. And yet these people really are imagined as not being here. It's illogical, and that's the law from 1891. And like Amanda was saying, part of what matters here is the plenary power of that currently exists in immigration.
Yeah. These are wonderful, and we're trying to get to as many in the chat as possible. I'm seeing a lot more questions about resistance strategies, what you've seen as far as the history of resistance to ICE and deportation, that question about sanctuary cities and that local form of resistance. So if y'all could speak to a little bit more to that, especially about what you've seen work or be effective.
Communities defend themselves. And that is important. So, for example, if immigrants see, or if someone from the community sees an immigration official somewhere roaming around in, in a car, they call the radio, and the radio announces, hey, don't pass through this street is dangerous. So there are ways to communicate danger that these are not news. We see them in the 1970s. In terms of resistance, we see, for example, that when ICE agents come into houses, people often don't open the door. They don't have to. Without a warrant, these agents can't come inside the house. So knowing your rights is extremely important. And that's why we see so many campaigns nowadays about know your rights. Again, going to protests, I think, is important. Writing in local newspapers, talking to your neighbors, because this is a cultural war. If we don't win the cultural war, we can't win. If Trump won, and partially because of the issue of immigration, is because Americans are scared of immigrants, and we need to change that narrative.
Yes, and I fully agree with all that. And actually, my students have been doing a lot of know your rights presentations, guardianship, drafting guardianship documents. So if people are deported, their children have someone to take care of them, arranging bank accounts and housing situations such that if they are deported or detained, their property won't be taken from them. So there's all that kind of work. But in terms of resistance, I guess where I'm at right now is the point, I think it's my theme that I've been trying to focus on this past hour, which is if we're in a post-empathy moment, and I fear that we are, to let people feel how this is going to affect them. And there's a sense of, well, this is, either I like it or I don't, but it won't affect me. And I think it's going to be a wake-up call. For example, if undocumented immigrants in Texas that are 8% of the workforce are either, all deported, very unlikely, or nonetheless pushed out or stop working, the economy of Texas would crater, right? And I think one of the major reasons Joe Biden lost, and I understand it, frankly, is the inflation and the cost of food. I talked to a lot of people who are really hurting. I noticed the price of food, and I can afford food, but it was expensive to shop for me and my family. The price of food will go up if we get rid of undocumented immigrants. And it doesn't mean we shouldn't try to fix what I think is a broken system. We should. But the idea that the solution to this is to deport the people that are harvesting our crops, over 70% of the people that harvest our crops are undocumented immigrants. That's a conservative number. And the idea that we think they're the enemy, that's the problem. So I just want people to feel it. Okay, if we deported them, your food would cost more. By the way, your uncle who runs a small business, he's not vetting people. He could be fined or even jailed because he's hired undocumented immigrants. Oh, your neighbor who takes care of your kid, turns out doesn't have safe, secure status. TPS ended for that person. She's gone. Oh, your kid's best friend in school, suddenly they're rounded up along with their family and deported. I guess I want this sense of it's not some fringe group. It's 15% of the United States are foreign born. And of course, we get rid of birthright citizenship, we're going to see a whole lot more people at risk. And that's the sense that I don't think we've conveyed well enough. I think there's a sense that it's criminal aliens who aren't really part of my community. And that's the message I want to give. And the message is not, and it's a humanitarian goal. We need to be nice to those people. I feel that way. I'm sure everyone here does. But that's not the message I want to send. I want to send, it will hurt you and your pocketbook and your day-to-day life to lose people that live among us and work among us and are so essential to our economy. That's the message I think would be most valuable.
Those are both helpful. I want to pause to give folks the second CLE word. The second CLE word is refuge. So our first word was harbor, second word is refuge. I also want to let folks know about an ACS specific opportunity to volunteer. It's called the Just Futures Law Project, and they're working with grassroots and movement group in the immigrant rights area. So I'm going to paste that in the chat, and you can reach out within ACS to get involved to my colleague, Ashley. And last but not least, we've got an event coming up next week that's going to look at state courts. There's efforts to push progressive judges off the North Carolina court, among other. That's called, I think it's Who's to judge? Yes, who's to judge, protecting the legitimacy of state courts. So please check that out on the website. But with my last question, I want to ask you both, because we're so often on the defense on immigration, like mitigation of the next new terrible idea that's come up with. But what would you affirmatively like to see evolve in the law? What if there's two or three areas where you'd like to see the law positively shift for immigration, what would those be?
I think there's a couple of things that I would like to see. The first one is an increase in the number of visas that are allocated. And then when people were when Congress was debating the 1965 law, there was a lot of pressure to increase the limits on the number of people who could come. Right now, we have an authorized migration in part because there's a mismatch between the people who are needed for labor, as we heard from Amanda, and the number of visas available. So people keep coming to work because they find jobs. Also for other reasons, like they find safety, asylum is guaranteed by law. But there's a mismatch between opportunities in the United States and the number of visas available. So people come without papers. The second point I want to make is that this is not simply an immigration question. We cannot address the issues of immigration by only focusing on the United States. Right now, the cut on US aid is, of course, by creating problems in people's home communities, by not helping to improve them, problems are going to arise and people are going to come in greater numbers. So I think this needs it's a transnational problem. It needs a transnational approach where we think about how to contribute to solve issues of crime, issues of unemployment and underemployment, but also increasingly environmental issues that are occurring in people's home countries as a result of climate change.
Yeah, I would just second what everything Anna said and say the last time we set our number of employment-based visas was 1990. That's before the internet. I want to see us stop talking about humanitarian relief for immigrants and start talking about all the ways in which we need them for our economy, and to expand the number of legal immigrants coming to work in the US, which is frankly what they're doing already. We just think of them as asylum seekers who need our help when actually they're driving our economy.
Absolutely fabulous. And thank you to both of you. And also thank you to the audience. Y'all have been extremely engaged in the chat, and I apologize if we haven't been able to get to each one of your questions, but I hope that you'll stay engaged with ACS. Please feel free to reach out to us and we will direct you to opportunities. And it seems like the biggest takeaway that I'm getting from both of you is just to stay engaged in this fight. It certainly did not start in 2025 or even in 2020, and it's a long haul and we have much to learn. So thank you very much and have a great afternoon, everybody.